collaborative family law is not being sold on the basis that it is necessarily a cheaper option. What's being sold is the fact that it is a quality option. People are far more aware of their relationships, and particularly relationships with children. And if the children can see that the parents are dealing with their issues in a non-confrontational way, then they will benefit from that.
It can be expensive because there can be complex financial issues that need to be resolved. What it does do, as against traditional litigation, is give the divorcing couple far more power over the amount of money that is spent. Because it's meeting-based, they can see precisely where their money is going and can do as much as they are possibly able to do to contain the costs by providing the information and being constructive about the use to which that information is put.
It's difficult to generalise about timescales because in the conventional process there can be some separation and divorce settlements which go very speedily and others which sadly take years and years. But in general, the impression that I have is that the collaborative law process works more quickly. And that could be for many reasons. I think it's clear that the people who are engaging in that process are keen to do it and want to get things sorted out. And that in itself helps to speed things along.
Collaborative process allows for advice in the room, around the table, whilst the collaboration is ongoing. And so it enables couples to access personal, tailored advice, which can actually allow for breakthrough solutions to be reached that much more speedily.
One of the other big differences between the conventional process and collaborative process is that although time is spent in meetings, time is saved by not having the normal conventional correspondence between the parties and their solicitors, because we do it mainly at the meeting and it's done there and then. Sure, people go away, do their homework, they may meet with their own lawyer to check what's being produced and make sure that it's what is needed, but there isn't the welter of correspondence that goes backwards and forwards with questions and answers and so on. It's mainly at the meetings.
Mediation and collaboration are quite different concepts. Mediation requires a trained mediator to facilitate discussion between two parties. That mediator might be a lawyer, might not be a lawyer. The mediator is not there to advise either party. Their role is purely to facilitate discussion and perhaps, if they are legally trained, to give neutral legal information.
So in mediation, the mediator will facilitate a discussion, the couple will each go their separate ways for legal advice. In collaboration, the legal advice is there on the spot, up for grabs and up for discussion in a mature way between all four people participating in the collaborative discussion. There are a huge number of benefits from the collaborative family law process for an individual, or indeed a couple, that are of the right mindset to embrace it. To be specific, if you're looking at a financial issue, you might find that one party to the marriage has got really detailed knowledge of the financial arrangements of the family and the other person hasn't. If you're going through the process of litigation, that information is communicated generally by letter and by forms, which themselves beg further questions. If you've got two solicitors collaborating with an estranged couple, all four people can look at all of those documents together, and rather than correspondence going to and fro, you can have a very sensible discussion about what very often can be very complex and daunting issues for certainly one person in the room.
One of the advantages of having the four-way meetings is that you're able to correct information straight away. If one person says, might seem a trivial point, we were married in 2004, the other one says, no it wasn't, it was in 2003, that information is corrected. It's the same with the financial figures. If you're looking at accounts and somebody is able to say, well, I can explain this particular figure, that's why it's different. So you're having a level of openness.
This way, because there is a trust and transparency between all of the parties, that's the lawyers and the clients. It's round a table, and so people can speak more openly and freely without any fear that it's going to rebound on them later.
There might be a situation perhaps where there's been violence and the parties don't feel, or one client doesn't feel that it's appropriate to sit in the same room. There might be a situation where it's important to get a petition issued because there is a jurisdictional point. It may be that the husband's position is better if the parties can issue in a different country. And in those circumstances, collaborative law may not be appropriate. You'd have to look and consider very carefully all the other options.
At the beginning, there is a commitment on the side of all parties not to go to court. And that commitment is reflected in a contract which is signed by the parties and their solicitors at the very first meeting that takes place. So straight away there is an understanding that wherever you go with the process, you're not going to court.
In their raw state on the breakdown of a marriage, it's going to be difficult to engage in the collaborative family law process unless they involve a family therapist or a counsellor. Family therapists and counsellors are still not welcomed by everyone in Britain today, but they do have a really critical role in getting people into the mindset that can then produce the satisfaction all round through the collaborative family law process.
When the client can't cope or is frightened to go in the same room as their potential ex-spouse, they advise that they go and see a coach to be able to build up the confidence and build up their internal strength so that they then have the actual courage and the empowerment to be able to go back into the rooms and deliver the four-way process and then create the way forward that they want to create.
Clients get a team around them, and therefore you have the specialty involved in that team. You're not got a jack of all trades trying to do everything. You have people who are have special knowledge and skills at what they do.
In order to conduct CFL effectively, you have to be open to other people. I think that is so important. There's no point in trying to get involved in the collaborative law process if you're used to getting your own way or you're bent on getting your own way. It's a team. And you need to be prepared to accept that you might be only one of the players in the team. You're not the main event.
There are three models really of resolving family disputes. There's the traditional arrangement solicitors writing backwards and forwards and using the court process. There's the mediation model, which again has become quite important recently. And thirdly, there's the collaborative law process. The collaborative law process is going to be attractive to those people who want their own lawyer next to them when they're negotiating a settlement, either about their finances and/or arrangements for the children once they've separated, living in separate households.